Hello, thank you for listening. My name's John Huddle, and today's post is called Conundrums and Complications. We're going to be talking about what happened in Asheville, North Carolina, June the 18th at the U.S. District Courthouse in the case of the United States versus Diane McKinny, where she pled not guilty and was given a $500,000 unsecured bond. Before the initial hearing started on Monday in front of Magistrate Judge Dennis Howell, the court atmosphere was relaxed and filled with conversations between McKinney's defense attorney, Mac McKellar, and other court participants. Mr. McKellar was obviously known by all of the regular court staff. He gave the court reporter a hug in the friendliest way and received a warm welcome from the magistrate once everyone was in their place to start the hearing. The hearing started about 10:13. Magistrate Howell led by outlining the order of proceedings. There would be an initial hearing, a detention hearing, and an arraignment. He started by asking Diane several introductory questions meant to establish her ability to hear, read, and understand the procedures as each step occurred. He read her a list of rights, including not saying anything and a right to a jury trial, as well as others. Soon he was reading the multi-page indictment, which served as a foundation for the other steps that would be taken during the session. As with Jerry Gross and Jason Gross, Magistrate Howell took extreme care and consideration to ask questions meant to secure Diane's agreement that she understood the process unfolding. He read each word of the indictment, which took a while. He was very engaged. I provided a copy of the indictment in my last post and will not go over all of it here. Not mentioned in my last post was the forfeiture judgment sought for $309,660. This amount represents the sum of benefits believed by the investigators which was acquired by fraudulent means. As procedure, the magistrate advised Diane she had three choices for representation. She could represent herself, she could hire an attorney, or she could apply for indigent status, and after a review of a sworn signed financial affidavit, she could be granted a court-appointed attorney. She chose to complete the financial forms and asked for a court-appointed attorney. In this case, it was Mr. Keller. The list of requirements for the pretrial release conditions were read by Magistrate Howell. Right away, the complications began to surface. Diane McKinny is still employed as the bookkeeper for Kent Covington. During the time in question, she worked in those duties for three companies owned or managed by Mary and Kent Covington: Diverse Corporate Technologies, otherwise known as DCT, Integrity Marble Incorporated, doing business as Integrity Marble and Granite, and during the time in question, Skycatcher Communications. These were the companies listed in the indictment. Her continued employment for Kent posed a problem in that a few of the affected DCT employees from the time period in question remained employed today. Discussions began to resolve the issue, since McKinny is not allowed to talk to anyone who would be called as a witness in the case or possibly in other related cases. The magistrate again, as in the Gross hearings, expressed the requirement for McKinny to strictly adhere to this condition. He warned her that if it was discovered that she had talked to Kent, present employees, or anyone else who is a witness or could be called as a witness in the case, except for her attorney and the investigators, her bond would be revoked, a warrant for contempt of court issued for her arrest, and she could be sent to jail and possibly fined. A major conundrum was discussed in that McKinny is still a part of the, quote, church community, Word of Faith Fellowship, of which many members are subject to several ongoing investigations. The magistrate stopped short of telling Diane she could not go to work or to church, but he emphasized again that she is forbidden to discuss this case except with her attorney or investigators. The list of limitations on Diane in many regards mirrored those of the Grosses. These include, but are not limited to, the restricted travel to the District of Western North Carolina, to the District of South Carolina. She's to give up her passport and not apply for a new one. She's to own or possess no firearms, no violations of the law, including report even if she gets a speeding ticket. She's not to partake of alcohol. She's not to be doing drugs or hanging out with those that do. She's agreeing to random drug testing. She's agreeing to submit to a DNA sample if requested. Additionally, her home, her car, her cell phone, or any computer she has access to, all are subject to random searches. Also, she was to meet with a probation officer to discuss other limitations and requirements. The major conundrum which surfaced with the Grosses and with Diane was how to limit the contact with those who may be witnesses in the case. Next Monday, this same complication will be discussed. A possible solution would be for their counsel to advise them that until the trial is over or the outcome is known, listen to the sermons from home, whether it's over the telephone or over the internet. Not as discipline, but as a precaution to keep them free from compromising conversations. Kent's indictment includes the allegation that he used his authority within the church community to coerce compliance to the illegal scheme. Will it be prudent to advise Kent to take his church involvement over the phone or over the internet? During the arraignment hearing, McKinny pled not guilty and was issued a $500,000 unsecured bond. The court date was set for September the 4th, 9 a.m. in courtroom 1. An open file policy on behalf of the U.S. Attorney was confirmed. This may speed up the defense's access to the evidence or discovery held by the prosecution. By 10:54 a.m., the hearing was complete. Diane had a couple other meetings to attend. Her attorney presented me and the other media with his card and said, "No time to talk right now. Send me an email and I'll answer your questions as I can." And then he said, "We will present a vigorous defense." Monday was a beautiful, hot, and humid day in the mountains of western North Carolina. In many ways, this day in the U.S. District Court served as a warm-up for next Monday. Kent Covington is cast as the instigator and developer of this illegal scheme, along with McKinny. For those familiar with both parties, who do you think took the lead in birthing the scheme? One has to wonder if either of them will turn on the other as the main promoter or driving force behind this alleged crime. Once each of their attorneys views the discovery and evidence against their client, will they strategize to reflect the guilt on the other defendant? Or will a new person be named as the master of the plan or fraud? Adding to the complicated dynamics of this, quote, church community, close quote, is Kent's marriage to Brooke, who is known as top-tier leadership within the Word of Faith. Will these factors complicate things even more? With the trial for McKinny set for September in front of Judge Martin Redinger, one wonders who might be indicted in July. It appears there will be more fireworks in the days to come. I believe the conundrums and complications will continue to multiply as more individuals are indicted. Members and business owners will decide if their loyalty to the Word of Faith Fellowship is worth the risk of jail time. Has it come to this? Yes, it has. The cost of being a faithful Word of Faith member is higher than many expected. Do you agree? Thank you for listening. Please subscribe to my YouTube channel, religiouscultsinfo.com, my blog by the same name, religiouscultsinfo.com. Follow me on Facebook at John Huddle, author, and we will see what next Monday will bring. Thank you for listening.